Hello, CryptoQ Media. I appreciate you stopping by my channel. Ripple's XRP leader puts future intentions out there and dismisses settlement rumors. Rumors about a pre-trial conference in the SEC complaint fade as Stuart Alderoty clarifies the pending SEC v. Ripple case. Any possibility of reaching a resolution is now severely limited by this. Many XRP members were hoping that the conference would put an end to the drawn-out legal dispute. The penultimate pre-trial meeting will be presided over by Magistrate Sarah Netburn, according to the court's scheduling order from last year. According to Alderoty, the pre-trial meeting was meant to indicate that the litigation was getting close to a settlement. However, after the SEC withdrew all allegations against individual defendants Brad Garlinghouse and Chris Larsen, Khalid, Ripple's chief legal officer, ended the session. Chairman Alderoty cancelled the last pre-trial session. The SC case's future steps were likewise covered by the Ripple Club. Ripple will respond to the SEC's remedy brief, according to Alderoty. The filing demanded a fine of approximately $2 billion. Although the motion will be presented under seal, a version with the necessary redactions will likely be made public. Please take note of this. In a subsequent statement, Alderoty brought up the fact that the SEC will also submit its response to the disagreement on the settlement that Ripple's initiated. The SEC Ripple case has reportedly been the subject of much discussion as of late. It was already scheduled for a settlement meeting amongst the involved parties. No one has seen the meeting minutes, but several excerptionados are hopeful that the case might be resolved soon. Even before the SEC's recent closed-door meeting on April 11, these rumors had begun to circulate. According to prominent XRP user Ashley Prospero, the delay in the distribution of 500 million XRP from escrow is one of the numerous reasons why the SEC versus Ripple case is likely over. There was an original plan to issue 1 billion coins this month, and the 500 million XRP that were released from escrow were supposed to be included in that. Cryptocurrency investors were led to believe that Ripple was using stock market manipulation to fund its SEC settlement. Although the system was unable to unlock all 500 million XRP on April 1 due to an issue with the escrow address, the remaining 500 million XRP were successfully unlocked. Waves, the answer to the most alluring treatment, and Aldo's latest tweet ending the settlement rumors have all taken front stage. Institutional clients that lose money on their XR purchases are the only ones who can get their money back. The decision in SEC against Gulf of litigation has been interpreted based on a Second Circuit ruling, according to Waves. If the judge finds in favor of Ripple, only institutional investors who purchased XRP at a price higher than its current market value will be required to pay disgorgement. Therefore, many of the lawyers who are following the case have seen the recent rumors of a potential settlement between Ripple Labs and the U.S. Securities and Exchange Commission with skepticism, if not outright rejection. This is because Ripple is facing a $2 billion fine from the SEC and was recently ordered by a judge to produce extensive financial data pertaining to its institutional sales of XRP. There has been a recent shift. This judgment has inadvertently increased the level of conjecture surrounding a potential settlement. Judge Sarah Netburn has issued a court directive that has 8 days to postpone the legal processes. Now that Ripple has extra time to meet the financial disclosure requirements, commentators are speculating about a possible settlement. Despite the set deadline for remedy stage rebuttals, there is still no clear resolution to this narrative. Therefore doubt will persist for the next 3 months. Arguments against the pointlessness of a possible settlement between the SEC and Ripple. Legal figures within the XR community have vehemently refuted and discredited the settlement assertions. Settlement talks are secret and protected by law, according to an experienced attorney named Bill Morgan, who stressed the significance of keeping them hidden. Some people may not know this. This might be hard for some people to grasp. So, until an abrupt agreement is made, there is no indication that a settlement will ever be reached. Jesse Hines, who was just as well versed in the law as Morgan, wholeheartedly agreed with her comments. Declined to acknowledge the rumor's veracity. Speculation about a possible settlement between Ripple and the SEC is just that, speculation, until a settlement actually happens. When they do make it into the public eye, it's typically as a ruse to get more influence. Hines cautioned against relying on the nonsense. Mark Fogg, a former securities lawyer, brought some cynicism to the table by making fun of the prospect of leaks in such high-stakes legal proceedings. It was standard practice for him to reach out to an anonymous and reliable Twitter account before initiating settlement discussions each time I was embroiled in a previous legal battle with the Securities and Exchange Commission. The likelihood of the disclosure of sensitive information was stressed by Fiegel in his response. Morgan continued by saying that of the hundreds of mediations she had been a part of over the course of 26 years as a mediator or lawyer, not a single one had ever broken the confidentiality agreement or disclosed material. Since the initial lawsuit was filed in December 2020, Ripple has encountered substantial legal challenges. Despite the unpredictability of regulations having a detrimental impact on the XRP market, the Securities and Exchange Commission (SEC) has been investigating the company's institutional XRP sales. Ripple has won significant victories in these instances. The court's decision that XRP does not constitute a security and the rejection of the SEC's case illustrate this point. Reports indicate that a deal has been reached regarding the long-running legal dispute between Ripple Labs and the U.S. Securities and Exchange Commission. The rumor mill is circulating that the settlement applies to Ripple CEOs Brad Garlinghouse and Chris Larson. Regardless of these murmurs, the XRP price has persisted in its declining trend, which started more than a month ago, and has fallen by about 3% in the past day. However, there is some good news for cryptocurrency investors. A settlement is currently in the works. The outcome of the case brought by the Securities and Exchange Commission could signal a return to the cryptocurrency's previous shape, which would be great for those hoping for a rally to coincide with the much-anticipated Bitcoin halving event. Ripple XRP is targeting 60 cents in April, and the SEC lawsuit is commencing at the perfect time. Therefore the two parties may have already agreed a settlement. Over the past several years, the two parties have been embroiled in a massive court struggle, with Ripple coming out on top many times. If you're new to my channel and have just subscribed, I appreciate it. Later, I will see you.